Well, there's little doubt that it is a controversial subject. And Bill C14, as it was called, the legislation dealing with medical assistance in dying, received royal assent in this country on the 17th of June in 2016. When it was released, a highly topical decision, a lot of people not happy with the inclusion or the exclusion of individuals from being able to ask for physician-assisted death. Colin Flannigan from FH&P is in our studios this morning. Mr. Flannigan, good morning to you.
Good morning, Phil.
This is a conversation that I think indirectly goes back to the decision of Carter versus Canada. As the decision was released by the Supreme Court in 2015.
That's absolutely correct. So before we really get into some of the nuts and bolts, I just want to do a little bit of a introduction to the topic.
Sure.
I understand that, it can be a controversial topic. I know that there's some very strong feelings on both sides of the argument. Some people feel very strongly in favor and are very pro with dying with dignity. I know other people feel that legislation either is wrong in its essence or goes too far and are concerned either about euthanasia and about slippery slopes. And I can respect and appreciate both sides of that argument. The way I look at it is, from my perspective as a lawyer, I've got an oath to uphold the law in Canada. And this is the way the law currently is. And my job is to help make sure that people understand the law.
Provide direction and guidance.
Exactly, and help guide clients through the process as well, too, which I have had that experience in guiding a client through this process as well, too. So I don't look at it in the sense of whether or not some people feel that this is a right or wrong situation. I look at it as this is the way the law currently is, and my job as a lawyer is to help people through that.
Can I ask you, are you seeing within FH&P, or you particularly, are you seeing more, at least inquiries from people who want to know more? Is there not a rising tide, but is there a rising level of interest on the part of individuals? Whether or not they ultimately write documents or take it further, are you being asked?
Absolutely. And the way I look at this is I think there was already clear understanding that this was a topic that a number of people were already interested in. I think the volume of interest, though, is perhaps even surpassed and surprised expectations. Both clients as well as personal friends as well, too, just even having conversations with people trying to see what people know about it. And I know I've got friends that, like I said, sit on both sides of that argument. Some feel that they dislike it because they feel that it is too far, that it is morally or ethically wrong. And I know other people that think that it doesn't go far enough, that there's a lot of people that are excluded from this possibility.
That more than the other way, I think. I think there was a lot of anger in the land when people dealing with a disease such as Alzheimer's or dementia effectively were excluded from writing directives or orders.
Well, and I think this is where we kind of tie into 2 weeks ago, the last time I was on the show. We're talking about advanced healthcare planning. We're talking specifically about representation agreements and, in a way as well, to advanced directives as well, too. So this is a topic that ties into the medical assistance in dying or assisted suicide. I do appreciate that the appropriate vernacular is the medical assisted in dying, so I'm going to try to stick with that. The way I look at it is this, is in order to understand those concerns about potential shortfalls in the legislation, I think we really need to understand what the law was prior to the Carter decision and what actually occurred with the Carter and Canada decision. And you've already hit the nail on the head there, that is a key point to look at to really understand why the law is in its current state, what the current state is, and exactly what we can expect going forward as well, too. So, with no further ado, let's talk a little bit about Carter.
Okay.
So going into Carter, we were looking at a situation where there was a blanket prohibition against assisted suicide in any form. And I'm going to use the term assisted suicide here because this is well before the introduction of what we know as medical assistance in dying. At that point, it was just prohibited under the criminal code. It had been addressed in front of the Supreme Court in a case called Rodriguez in British Columbia, the Attorney General of British Columbia. And that was a 1993 Supreme Court of Canada decision. Now, the primary focus on that case, it did deal a little bit with Section 7 of the Charter. Once again, it was a charter case. It dealt with a little bit. Section 7 is dealing with the freedom of life, liberty, and security of the person. It dealt more with Section 15 of the Charter, though. And this was more looking at the question of whether or not this blanket prohibition against assisted suicide violated and discriminated against those with disability or disease. And the way the court looked at it, they felt that there was no halfway measure that could be relied upon with assurance. Now, basically what that's saying is that at that time, the court considered what was the available evidence, what was the documents that were introduced to the court to look at and review. And a lot of this was looking at, okay, in 1993 and in the trial decision prior to that, what was the landscape for assisted suicide throughout worldwide and throughout in Canada? In Canada, there was obviously a blanket prohibition on it. There was some social movement seeking towards it, but you were also looking at a worldwide scenario where there weren't many jurisdictions. I believe at that
Netherlands.
time, I think there was only the one, Netherlands, at that time.
Yeah.
And there was little supporting documentation as far as safeguards. And safeguards is an important aspect that we're going to get into both with Carter as well as the current legislation.
I think that we need to recognize the bravery of Sue Rodriguez because I covered the case. I was in the courtroom. I watched as she, Lou Gehrig's disease was her disease, and effectively the woman was dying right before her eyes, our eyes. She was in tremendous pain. She was effectively strangling to death within her own body and was asking the permission of the courts to take her own life with the assistance of a physician. And I can remember a member of the NDP, Sean, sorry, the name just went out the window. But at the same time, he indicated that he would stand by her. And as she was refused by the Supreme Court of Canada, there were thousands of people who were so saddened that the Supreme Court ruled against Sue Rodriguez. It was a crushing blow to her because she and her legal team felt that they had delivered the case that justified not a blanket a policy, but at least to allow this individual, this woman, the right to end her life. And when the court said, no, you cannot, we force you to continue to live this terribly painful, terribly tragic life, a lot of people suddenly found themselves saying, this is not the Canada I know.
Well, I think that's some very important questions you raised there and some important points. However, one thing I want to address with the Rodriguez decision, and important to consider in this, is what the ratio of the court was in that decision. It was a very close decision. It was a 5-4 split. 9 Supreme Court justices sat on that decision, and it was a close decision. And it should also worth be noting that now Chief Justice Madam McLaughlin was writing on the dissent side.
Yes, at the Rodriguez decision, she wrote on the dissent. When the Carter judgment came forward, she was then the Supreme Court justice.
She was the Chief Justice at the time for the Carter decision, and was I think it's worth noting as far as knowing who the Supreme Court justices are, and understanding their judgments and understanding how they view things as well too. Because when it comes then to looking at Carter a number of years later, we can understand, okay, who were the justices that sat on the Rodriguez decision? What were some of the factors they considered? And what were some of the things that they felt were important? Because when we look at the question of the Carter decision, so we'll look at it from both the trial decision, because the trial and the BC Court of Appeal decisions are both important as well, and then how that led into the Supreme Court of Canada. So in the trial decision, we were looking at a scenario where, once again, we have a lot of evidence being brought in front of a judge to make a decision, a Supreme Court or British Columbia Supreme Court justice. And we had a lot more to go with in this one. We're looking at a scenario where both internationally, there are far more jurisdictions that permit assisted suicide. There is far more data available as far as safeguards. And that, once again, I'm going to reiterate on that point because the importance of it does come up again later. As well as within Canada. It's also really worth noting, and this is something that was stated expressly in the Supreme Court of Canada decision in Carter, was not less than 6 debates in the House of Commons occurred after the Rodriguez decision about potential bills addressing assisted suicide. Mm-hmm. The socio-political landscape in Canada was different than when Rodriguez was decided. People were talking about it and looking at the subject differently. And this comes to an important question on what's known as legal principle of stare decisis, which is saying that was the trial court in Carter, the British Columbia Supreme Court, obligated to stick or strictly adhere to the Rodriguez decision and deny this challenge against the criminal code provisions, this blanket prohibition? And the question raised then is, well, when does a court, because the way I look at it is this, the Constitution is often referred to as the living tree. Section 1 of the Constitution states that there can be infringements on charter rights as long as they can be justified in a free and democratic society. What can be justified in that free and democratic society changes with our society. So the law can change and evolve as our society evolves.
Recognizing the attitudinal change of the population as a whole.
Exactly. So when we're looking at when the trial court should or should not adhere to the higher court. Now, the general rule of thumb is they always should adhere to the higher court, but there can be exceptional circumstances. In this one, we were looking at it that there was a new legal issue being raised, and there was such a change in circumstances or evidence that it fundamentally shifted the parameters of the debate. And this has a lot to do with both the evidence that was before the trial court, being that there was so much more evidence available for different programs and regimes in other jurisdictions, as well as looking at that shift and change in our society. So when we
have to take a break here. We're against a clock a little bit. Colin Flannigan is in our studio this morning. We're talking about physician-assisted death, dying with dignity, the societal changes that have taken place since the day when Sue Rodriguez petitioned the Court of Canada, the Supreme Court of Canada, for the right to take her own life. Back in a moment with Colin Flannigan. Colin Flannigan from FH&P. To some of you, you might find this conversation tough to listen to, but the reality is that in this country right now, there is a movement in the land. There is a change in attitude within Canadians, such that something close on 70% of Canadians believe that it is time for the country to put in place provisions to allow physician-assisted death with dignity, whom we've interviewed numerous times on this program, continue to be one of the central voices, one of the voices championing the change in the country. As Canada's Solicitor General, Judy Wilson-Raybould, released the decision and effectively also released the restrictions, if you will, that the Canadian government was putting in place. A lot of anger in the land and a lot of frustration in the land and a lot of people who were afflicted with early onset of Alzheimer's, dealing with dementia, who all believed that at last the government of Canada was going to clear the way for them to request physician-assisted suicide, when they suddenly discovered that physician-assisted death was not going to be available to them. For a whole lot of families, it was a crushing blow. With that as the sort of scene setter, if you will, back over to Colin Flannigan. Mr. Flannigan, were you surprised by the way that the decision was written by the federal government and the decision that was made by the federal government?
Well, I'll put it this way. When I first read Bill C14, the amendments to the Criminal Code dealing with medical assistance in dying, I'll admit that I was surprised reading through it, and going over a number of the things stuck out at me, and I wasn't sure I understood what the rationale was on it. So at that point, I reread the Carter and Canada decision, and it made a lot more sense. And I think that's where I understand that a lot of people are both frustrated on both sides of the argument. I think it really needs to come back to understand that Carter and Canada decision, because this both sets an understanding why the government now permits this for those that feel like it's unethical. But then I think for those that feel like it doesn't go far enough, I think they'd once again need to come back to this decision and understand what the court was truly saying in the decision to see why the federal government acted the way they did.
From looking at this, though, from a legal point of view, I can remember when the state of Washington, driven by Governor Booth Gardner, Governor Booth Gardner was suffering from and knew that he was going to be afflicted with Alzheimer's. It was coming at him. And he decided that he was going to try to change the law. And I can still remember one of the classic moments in time was Booth Gardner, governor of the state of Washington, arguing in favor of physician-assisted death. And right next to him was his son, who was as vigorously arguing against it and saying that his father should be prevented from accessing such. And yet the state of Washington has legalized medical aid in dying with very few restrictions. The fears that were expressed that suddenly death tourism was going to take place, that suddenly places that give license to are overrun by people who are assisting or looking for assisted suicide. None of that happens. It's the fear-mongering on the part of the opponents. So it is an emotional, very delicate dance that we're doing here.
It is, but the way I look at this is going to be some of the major concerns raised by the government in the Canada decision was issues concerning true and full level of understanding about the decision being made, safeguards against coercion, duress, undue influence.
Where somebody is trying to convince mom that she should end her life because really what the initiative here is the kids want the money.
There is a concern there, and I don't want to make any level of judgment or comment on that level of argument, but the way I look at it is this was something that was seriously considered by the Supreme Court of Canada. So when they were making their decision, they looked at Section 7 was the primary consideration. Section 15, the question about whether or not there was a level of discrimination, didn't even need to be considered by the Supreme Court of Canada as they had made their decision based on Section 7, that is security of life, liberty, and security of the person. The trial level decision dealt with both of those issues and made a ruling that it was an infringement on both that could not be justifiably saved under Section 1 of the Constitution under what's commonly known as the Oakes test. The BC Court of Appeal reversed that decision. They felt that there was certain levels of requirement on adhering to the Rodriguez decision, and that court was split on its decision, and then it came back up to the Supreme Court of Canada. So the Supreme Court of Canada looked at it, and they felt that some of the key points were that a major consideration had to be considered about whether or not the inadequacy of safeguards, that was actually devaluing human life, versus the dignity and autonomy of choosing when someone wishes to cease living.
Can you define safeguards for me?
Well, I think that is not clearly defined necessarily in the decision. It is addressed a little bit more in Bill C14, but it comes out in some of the key points that were considered in the Carter decision. So as an example of this, the Carter decision found that all three components of Section 7 were infringed upon. That is life, liberty, and security of the person. So in the way that it found each of those points, I think tells us a lot about where these safeguards actually come from then. So when we're looking at it from the on the life standpoint, what we're talking about is, at least what the way the court looked at it, was saying that forcing individuals to take their lives prematurely for fear of incapability of doing so when suffering becomes intolerable infringes on the ability to life. They looked at life not so much as being purely quantitative, but looked at it more as qualitative.
So if I can sort of translate that into the language of my bread and butter crew, what they're really saying is that even though you've been afflicted with a disease, and even though we can tell and know what the end result of that disease will be, we're not going to allow you to prematurely end your life because you don't want to get into the latter phases, the latter stages of that disease. So we're going to effectively, if I hear you, the law and the courts decided we're going to force you to go into the latter stages of that illness or that disease.
Well, I wouldn't say that. I think some of the evidence that was before the trial court in the Carter decision was saying this: when the disease is getting onset and getting worse, there is still happy moments. There's time being spent with family. And while someone is still physically capable of ending their own life, they find, or at least a number of people gave evidence on this, that they found it repugnant to even consider doing so because of considerations that they were still enjoying their life at that point. They knew it was going to get worse, but people were feeling forced to make that decision and end their own lives earlier than they would have wanted. I mean, when the decision was being considered by a lot of these people under these terminal diseases, they knew that they were going to have to make this decision at some point. But when someone wants to make that decision, was very personal and internalized. It was not like any one person could say, once this happens, once I become bedridden, then I'm going to want to make that decision at that point. No, it was based on a number of factors considering saying, no, I will know when the time is right for me. But when there was the blanket prohibition, forcing people, if they did want to make the decision to end their own lives, they would have to do so before they were ready to do it. And that's where the question came in, saying that the blanket prohibition violated Section 7 for life.
But effectively, we've removed personal choice. The courts become the ultimate arbiter. The courts become the decision maker. The courts become the ruling body. The courts become the force within the challenge that is facing the individual. The individual no longer can make that choice. You've closed the door on the individual, and I'm not talking about you, but I'm talking about the courts have effectively closed the doors on the individual. Need to take a break on this Tuesday morning. This is a conversation that is starting to heat up back and forth across the table with Colin Flannigan from FH&P. We're talking about physician-assisted death. Back in a moment. It's a conversation that has been held many times over kitchen tables, between families, family members, or as we are on this day in conversation with Colin Flannigan from FH&P and talking about the whole concept of physician-assisted suicide. And what in the minds of many people is the slowness of the government of Canada and the Supreme Court of Canada, the judiciary of this country, to opening the doors to giving Canadians the opportunity to determine what they're going to do with their own lives, as opposed to the judiciary stepping in with very restrictive provisions that prevent an individual from easily accessing physician-assisted suicide, and instead, because they can't, resorting to extreme measures. You know, people sitting in vehicles with a car hose attached to the exhaust pipe and literally poisoning themselves, or committing suicide with a gun. Very brutal, very harsh, and so tragic, so violent, I guess would be the word, when it didn't need to be that way. That there is a better way, but the government seems to be preventing access. Sorry, I'll get off the soapbox and get it out of the way, Mr. Flannigan. But those are the thoughts that so many people express to me that I've then become sort of a very verbal, vocal mouthpiece for.
And I understand the argument and the concerns, although I'm going to respectfully disagree with you that okay. I understand why the court decided the way it did. And based on what was in front of the court, I certainly can understand and respect the decision made by the court. So what we're looking at is, I think it's really worth understanding what the court was actually deciding. They were looking at a situation that the current state of the law said there is a blanket prohibition. This is what the law is, saying that there is, in the criminal code, it is a criminal offense to assist another human being in taking their life. They were looking at it as a challenge based on constitutional grounds. The ultimate law in the land is the Constitution. The goal of the courts is to make sure that they enforce the law. Now, understand that sometimes the law does change, and we're going to get into that in just a second, because if you look at it from this, if you've got a piece of law, in this case being a section or a couple sections from the criminal code, primarily dealing with sections 14 and 241, you're looking at a situation where the courts must first decide, do these provisions infringe on charter rights? First, in this case, they were saying that, okay, look, even though there's the Rodriguez decision, we're going to reconsider this issue, which is exceptional circumstances to even do that. They then looked at it and said, okay, is there charter infringements? And they came up with yes, yes, and yes, dealing with Section 7. They then need to look at it in the next sense of dealing with constitutional challenges. Can an infringement be saved under Section 1 of the Constitution, which says that an infringement of someone's charter rights can still be saved if it's reasonable or if can be justified in a free and democratic society? So what you're looking at then is there's certain legal principles that come back into play in that consideration. And these are going to be important considerations that the court looked at and wrestled with in the Carter decision. They looked at it and said, okay, well, one of the first considerations we need to look at is the absolute blanket prohibition, is it a situation where it's a rational argument? Is it something that is both what the concern is tied in and rationally connected with the implementation of the absolute ban? And they looked at it and saying that the main concern was it was to protect vulnerable persons from being induced to commit suicide at a time of weakness. And there is some validity to that argument.
I would agree totally, and everyone is familiar with that, and would agree that kind of safeguard needs to be in place to look after people who are being pressured.
Yeah.
But how is that allowed to roll over against all else?
So the way it comes into some of the next considerations then is, okay, yes, we've got a reasonable and a rational infringement, but that doesn't mean it necessarily is justifiable. And the next question then, it comes into questions about, is it overbroad? And this was a key question and gave serious consideration in the Carter decision and ultimately decided that the blanket prohibition was overbroad. There was a lot of people that were in a position that the courts were comfortable in saying that, yes, this type of person could make this decision. They could really consider, give informed consent, and that the assisted suicide would remove a grievous and irremediable medical condition. And that terminology is important because that comes back and deals with some of the actual infringements of Section 7 and the findings that the court actually made on that. So when we're looking at the next question then is, okay, we're looking at a situation where the blanket prohibition is overbroad. Too many people are caught in this blanket prohibition that are outside of what the reasoning is. So the next question then comes into minimal impairment. And we start looking at, this is where the court really needs to start struggling and balance considerations. And you start looking at it as, okay, there's a lot of people that very strongly believe we should have a far more inclusive regime in dealing with medical assistance in dying. But at the time when the court's considering this, they have to weigh up these different considerations and say, we are still having a reasonable and rational prohibition here dealing with certain types of vulnerable people. How do we balance protecting those people versus those people that are caught in this that really should be free to make that decision? And that's where they start coming back to, okay, what were the actual infringements the court found under Section 7? They go back through and they can really see where they're piecing it back together and saying, okay, if we're looking at someone who can make truly informed consent, because these are the ones that were having their charter rights being violated, someone that is suffering from the type of condition that is really in need of being addressed in this situation. And that question, I know the grievous and remedial harm situation is one that is a hot topic. And I know I'm going to get to the question about any future changes as well, too. We start looking at it and saying then, okay, where do you draw the line on this? Where is the appropriate situation? We're looking at it in the minimal impairment scenario. We're looking at a situation of saying we need to balance and put where that is. What safeguards need to be still in place to protect those vulnerable people that we still want to protect, and it's still a valid protection. Now, that's the way the law currently is. Will it change more? I think the question you've already raised as well, too, and I can sense in some of your concerns, is saying, well, there's other jurisdictions that seem to have fewer safeguards, that seem to have other functioning regimes, both prior to Canada. And the question is, why are we reacting the way we do? Why isn't this happening quicker? And I think that is dealing with the way the law was and the way that Canada traditionally looks at dealing with changes in the law. We tend to be conservative in the way we make changes in the law. They do come and they do change when our society changes, but this has to deal with the way our legal system is set up, that the change isn't quick. It does take time and take serious consideration, and legal principles need to be adhered to reach that point. So when we're looking at this, we are still in a situation where there's going to be further reports considered as well, too. Now, there was a release back in December of 2016 talking about what these reports are going to consider because of these particular hot-button topics that were not addressed in these changes. And some of these questions are going to be about dealing with what happens with the disease is purely a mental situation. It's not qualifying under that grievous and irremediable. What about the situation about advance directives? Now, going through the actual procedure on how a person engages the medical assistance in dying, making these advance directives becomes very problematic. It's a very kind way, I think, to phrase that, because of the wording in the Carter decision on wanting to make sure that vulnerable people are still protected, but that people that are free and capable of making their decision and that physicians are capable of making that assessment, that there are certain questions about onsetting diseases and when someone shouldn't be allowed to make this decision on an advance directive. And the way we're looking at it is currently, that's not the case. But it is going to be reconsidered. Question is, what can we reasonably expect of that? And that's some crystal ball gazing. It's impossible to say that, this is what's likely to be changed, in the future. I think it'll be a question of how does our society change and view this. And I think that you're right. You're hitting some nails on the head. That I understand that you do have a number of requests in dealing with questions about, well, this is the way society's looking. This is what society now wants.
And yet, we're going to have to take a break here, but I have interviewed people where I've said it is as simple as we need a psychologist's report saying the individual in question is of sound mind. Maybe not body, but definitely of sound mind. We need a doctor who has probably been acquainted with the individual for a number of years who can say, I can attest to this individual. I know them. I've known them medically, for the last 10 years. And a third individual would be a friend or a member of the family that says this person knows what they want. And those three voices should be able to resoundingly deliver a decision to a doctor or to a court and says, we certify that this individual should be allowed to take whatever course of action meets their particular needs, their particular wants, what they need to have happen for them in the context of their life.
I understand your argument, but I think we need to look at the actual procedure in going through medical assistance in dying. Going
to take a quick break. When we come back, also introducing into the conversation, it was just announced 2 days ago, the BC Coroner Service is going to start looking and conducting the first review of doctor-assisted deaths in the province of BC. Between June 17th of last year, when C14 was enacted, and January the 10th, there have been 188 doctor-assisted deaths in British Columbia. And the Coroner Service is now looking at them to see whether or not there are changes that be made to the program and whether or not it met the expectations of the individuals and the families concerned. Back in a moment. We have about 2.5 minutes with Colin Flannigan from FH&P. All I can suggest is that to those of you who are intrigued by or concerned about or would like to talk more with Mr. Flannigan to find out more about physician-assisted death, you can find him at FH&P. Just Google FH&P, and once you get to the pull-down menu of the lawyers who work at FH&P, Colin Flannigan is the gentleman that you would like to look to.
Well, Phil, there's to be perfectly honest with you, there is far more to discuss on this topic, and I think we've probably only touched about a quarter of the materials that I brought in for my abbreviated version of dealing with this. So what I'm planning on doing is I'm likely going to be doing some level of talks, perhaps, in relation to availability to the public. And when we make those decisions on through what organizations you might putting those on through, we'll put up news bulletins on our website as well, too. So anyone that's interested in attending is more than welcome to as well. Like I said, I do appreciate that this is a sensitive topic, but the way I look at it is no matter which side of the argument you're on, I think it's important to really understand it.
Is it the kind of thing that becomes a conversation at a coffee house with an individual sitting on a chair at the front of the room and a bunch of individuals gathered at tables around the room having a coffee and a croissant, and engaging in 2- and 3-way conversations in the course of an evening in a room?
I think it certainly can be. I think it's one of those topics that hits on so many different personal levels to Canadians. I mean, for those that have very strong religious beliefs that feel that it's unethical to take one's own life versus those that have witnessed family members dying before their own eyes and wanting to make that decision.
And for a lot of people, that becomes the bigger challenge is that just because you believe that it's a sin against God or whatever parameters that you're making that judgment in, you've suddenly decided that on my behalf, you're going to include me in your particular constraints or framework.
Well, in fairness, I don't think it's just purely religious concerns on ethics.
Colin Flannigan, FH&P, thank you for being here. We'll be back tomorrow morning at 6 o'clock on this Wednesday. Where will you be?